The courtroom was sterile, smelling faintly of lemon wax and bureaucratic indifference. When Martha stood to present her case, the bank's lead counsel, Marcus Thorne, didn't even look up from his tablet. He merely adjusted his silk tie and offered a thin, practiced smirk, the kind a predator gives to prey that doesn't realize it's already trapped. Martha wasn't just fighting for her late husband's life savings, she was fighting for the truth behind a balance sheet that had been scrubbed clean. Thorne knew the law, but more importantly, he knew how to hide behind the procedural machinery of the bank. He was certain this lawsuit would be dead before the lunch break. He was wrong. Thorne stood, his movements languid and rehearsed. He began his opening statement by dismissing Martha's claims as emotional grievances masquerading as financial litigation. He argued that the institution had operated within the strict boundaries of its regulatory framework, suggesting that the missing funds were a result of market fluctuations that any reasonable investor should have anticipated. He presented the bank's internal reports, pristine, digitized documents that showed a perfectly balanced ledger, devoid of the errors Martha insisted were present. The judge, a man whose patience for individual plaintiffs against major institutions was notoriously thin, watched over his glasses. He asked Martha's counsel for proof of unauthorized movement. When they presented their initial audit, Thorne barely suppressed a laugh. It was a secondary source analysis, riddled with the kind of assumptions that high-priced legal teams are paid to dismantle. Thorne cited the bank's standard operating procedures for asset management, emphasizing the transparency of their digital oversight. He turned the argument toward the complexity of modern finance, painting the widow as a confused outsider grappling with concepts that were simply beyond her depth. He highlighted the paper-to-physical ratio, a term that usually garners little attention in a local courtroom, and dismissed it as a conspiracy-laden distraction. He framed the case as a dangerous attempt to undermine public trust in the financial system. By the time he finished, the narrative was set. Martha was not a victim of a crime, but a victim of her own misunderstanding. Martha looked across the floor. Thorne caught her eye, his expression shifting from corporate detachment to something darker, a silent confirmation of his absolute control. He knew the internal records were impenetrable because, as far as the public record was concerned, they didn't exist. He had spent his entire career mastering the art of the off-book transaction, ensuring that while the bank's external-facing reports looked healthy, the true state of their physical inventory remained a ghost in the machine. He had successfully convinced the court that the burden of proof was an impossible threshold for a woman with a shoebox of statements and a fading memory of her husband's private discussions. As the judge leaned forward, preparing to deliver a preliminary ruling that would effectively gut the lawsuit, the atmosphere in the room shifted. A junior clerk, frantic and uncharacteristically out of place, rushed into the courtroom. She bypassed the gallery and approached Thorne's table, placing a singular, weathered leather-bound volume in front of him. It wasn't a digital printout. It was a physical ledger, hand-annotated, with dates that predated the bank's digital integration. Thorne's smirk didn't vanish, but it faltered. He recognized the binding. It was the shadow book, a relic he had assumed had been shredded 10 years ago during the last merger. It contained the real-time reconciliation of the physical inventory, the very thing the bank's public-facing software was programmed to ignore. The judge noticed the shift. Thorne's hands, usually steady as stone, hovered over the leather cover, hesitant to open it. The courtroom grew quiet, a suffocating silence that pressed against the walls. Thorne's hesitation lasted only a fraction of a second before he recovered, his mask of corporate indifference snapping back into place. He gestured for his associates to intervene, but the damage was already done. The judge, an old-school jurist who still preferred paper evidence to the abstract uncertainty of server logs, demanded to see the ledger. Thorne tried to pivot, claiming the book was proprietary internal data, irrelevant to the case at hand, and possibly stolen. But the judge was no longer listening to the smooth, rehearsed arguments. He reached out, his hand open, waiting. As the ledger was passed from the clerk to the bench, the air in the room felt heavy with the weight of decades-old secrets. Martha sat still, her heart hammering against her ribs, sensing that this relic from her husband's private desk, found hidden behind a false panel in his study just days prior, held the key to the entire charade. For years, the bank had operated on a dual-track system. the visible, regulatory-compliant digital interface that clients viewed on their apps, and the backroom, physical reconciliation that tracked the actual movement of assets. The bank's public narrative was a mirage, a carefully constructed illusion designed to placate regulators and satisfy shareholders, while the actual physical assets were being leveraged, rehypothecated, and drained into speculative dark pools. The judge opened the ledger. He didn't find sophisticated code or encrypted sequences, he found handwriting, meticulous, dated, and damning. There were names, account numbers, and specific references to physical asset allocations that directly contradicted the quarterly reports Thorne had cited just minutes before. The bank had been reporting full ownership of assets that, according to this ledger, had been moved into offshore custody months earlier. This was not merely a series of administrative errors, it was a systematic, top-down strategy of asset extraction. Thorne began to sweat. He leaned over to his assistant, his voice a low, urgent hiss, demanding to know how this specific volume had surfaced. He had personally overseen the purge of those records. But as the judge flipped through the yellowing pages, the scope of the deception became undeniable. The ledger detailed the paper-to-physical ratio that Thorne had so glibly dismissed. It documented a reality where the bank held 10 times the liability in paper derivatives as they did in actual, tangible bullion. They were playing a game of musical chairs with the depositors' wealth, betting that no one would ever demand the physical delivery of their holdings at the same time. Martha's husband hadn't been a confused investor, he had been the auditor who realized that the music was stopping. The courtroom gallery, filled with a few journalists and onlookers, started to buzz with quiet murmurs. Thorne tried one last time to regain the narrative. "Your Honor," he said, standing slowly, his voice losing its confident cadence, "this is an isolated artifact. It is an internal draft, potentially altered or misinterpreted by an aggrieved party. It does not reflect the audited reality of our current fiscal position. It was a classic deflection, an attempt to isolate the evidence and discredit its context." He was painting a picture of an rogue employee, a single point of failure in an otherwise flawless machine. But the judge wasn't buying it. He had found a signature in the margin, a stamp of approval from the bank's chief compliance officer, a man who had since been promoted to the board of directors. The ledger wasn't just a record, it was an instruction manual for institutionalized fraud. The judge looked up, not at the lawyers, but at the bank representatives sitting in the front row. The power dynamic in the room had shifted violently. Thorne, who had arrived as the titan of the proceedings, was now the one scrambling for purchase, his carefully prepared legal strategy crumbling in the face of raw, physical reality. Martha watched the transformation with a cold, hollow satisfaction. She realized that the missing funds weren't just lost, they were stolen to prop up the very institution that was now trying to sue her for defamation. The ledger served as the final link in a chain of evidence that connected the boardroom to her bank statement. Thorne knew that if this ledger were entered into the public record, it would trigger a cascade of investigations. Regulators, who had been content to look at the digital mirage, would have no choice but to demand a physical audit of the entire vault. The house of cards wasn't just shaking, it was beginning to collapse. The judge declared a recess, but the way he looked at the ledger, and then at Thorne, suggested that the bank's day in court was only just beginning. The smirk had truly vanished, replaced by the panicked look of a man who realizes he has left the safe wide open. The 30-minute recess felt like an eternity, a pressurized vacuum where the silence was arguably louder than the courtroom proceedings had been. Inside the holding room, Thorne was no longer the composed legal strategist. He was pacing the length of the carpet, his phone pressed to his ear, his voice a frantic, low-frequency tremor. He was ordering the immediate scrubbing of secondary servers and the redirection of internal traffic. He knew, with the cold clarity of a man staring into an abyss, that this ledger was the smoking gun. It was not just evidence of a single case, it was a map of a systemic contagion. Back in the courtroom, Martha sat still, watching the doors. She remembered the day she found the ledger. It hadn't been in a bank vault or a safety deposit box. It had been tucked away in the back of her husband's mahogany desk, hidden behind a loose panel that he had installed years before his unexpected heart attack. She recalled how, in the final months of his life, he would come home smelling of cold air and stress, his hands shaking as he poured a drink. He had been a low-level auditor at the firm, a man who believed in the integrity of the ledger as a religious tenet. To him, an asset wasn't a number on a screen, it was a physical weight, a measurable existence. He had spent his nights painstakingly documenting the discrepancy between the vault's actual content and the numbers the bank projected to the public. The ledger was the result of those long, lonely nights. Every page was a testament to a man trying to reconcile his conscience with the reality of his employment. As the judge returned to the bench, the atmosphere in the room felt electrically charged. The bank's legal team had clearly been scrambling to prepare a motion to suppress the ledger, but the judge had already sequestered it. He had ordered an independent, court-appointed auditor to verify the authenticity of the handwriting and the validity of the dated entries. Thorne returned to his table, his face a mask of pale fury. He attempted a final, desperate play. "Your Honor, we move to stay these proceedings pending an investigation into the provenance of this document. It is clearly a piece of fabricated theater, intended to manipulate the market and damage the reputation of a pillar of our financial infrastructure." The judge merely lifted an eyebrow. "Mr. Thorne, we are beyond reputation. We are now dealing with potential evidence of grand larceny and systemic fraud. If this ledger is verified, your client's reputation will be the least of your concerns." The courtroom doors opened, and a representative from the state regulator's office walked in, accompanied by 2 federal agents. The judge had not been idle during the recess. He had alerted the authorities, realizing that the implications of the ledger extended far beyond a civil lawsuit. The shift was absolute. The banker's smirk was long gone, in its place was a profound, hollow fear. Thorne sat down, his suit suddenly appearing too large for his frame. The auditor, a sharp-eyed woman with a reputation for uncompromising scrutiny, began the process of verifying the first entry. She used a high-resolution scanner and a digital comparative tool to check the ink composition and the wear on the paper against the timeline of the bank's history. It was a tedious, minute process, but it was essential. Every minute that ticked by felt like a hammer blow to the bank's stock price, which was undoubtedly beginning to react to the news of the investigation. Martha watched the auditor. She felt a strange detachment, as if she were viewing the scene through a glass pane. She realized that her husband had essentially been waiting for this moment, sacrificing his career and, in a way, his peace of mind, to build a time bomb that could one day bring the entire house of cards down. He had been a man who refused to believe in the magic of digital finance, insisting that at the end of the day, you must hold the gold, or you have nothing. The auditor finally looked up from the table. She nodded slowly. "The handwriting matches the bank's former auditor, Mr. Elias Vance," she stated, her voice echoing in the quiet room. "And the ink, the paper, and the procedural stamps appear to be consistent with the internal administrative protocols of the year 2018. A collective gasp rippled through the gallery. The bank had claimed that those records had been destroyed in a fire, a convenient narrative that had protected them for years. Now, that fire was revealed as a fiction. The ledger was not just a document, it was a confession. Thorne's defense had been based on the premise that no evidence existed, that the widow was simply a disgruntled claimant. Now, the existence of the physical ledger invalidated every argument he had constructed. The bank's representatives, who had been sitting with an air of untouchable authority, began to whisper amongst themselves. They were realizing that they weren't just losing a lawsuit, they were facing a total institutional audit. The game they had been playing, the paper-to-physical, shell game, was now public knowledge. And in the world of high finance, nothing is more dangerous than the truth becoming visible to the public. The courtroom had transformed into a laboratory of institutional exposure. With the ledger verified as authentic, the proceedings shifted from a standard civil dispute into a forensic excavation of the bank's internal machinery. The auditor began the process of breaking the code, translating the cryptic, shorthand notations her husband had used to describe the movement of physical assets. It was an intricate puzzle, rows of alphanumeric strings that represented the vault-to-vault transfers, the shadow loans, and the synthetic products that had allowed the bank to inflate its assets on paper while hollowing out its physical reserves. As the auditor read aloud, the complexity of the scheme became clear. The bank had mastered a technique known as fractional allocation. They would take a physical bar of silver or gold and collateralize it against multiple different digital claims. They were betting on the statistical probability that only a small percentage of their clients would ever demand physical delivery at any one time. If everyone requested their assets simultaneously, the bank would be exposed as insolvent. The ledger provided the mathematical proof of this imbalance. It mapped out exactly where the physical bullion had been diverted, often into private, offshore holding companies controlled by the same board members who had been telling shareholders the bank was fully backed. Thorne, now stripped of his earlier bravado, tried to object to the auditor's interpretation, but his interventions were weak, almost reflexive. The judge overruled him at every turn. "Mr. Thorne," the judge noted, his voice hardening, "we are past the point of legal semantics. The ledger clearly defines the difference between a custodial asset and a hypothecated liability. Your firm presented these to the public as the same thing. That is not just a regulatory oversight, it is a fundamental breach of fiduciary duty." The gallery sat in rapt attention. This was the moment where abstract finance turned into a visceral, human tragedy. The ledger wasn't just a collection of numbers, it was a list of names, the people whose savings had been used to plug the gaps in the bank's speculative failures. Martha recognized some of the names. These were people from her husband's social circle, families who had trusted the bank with their life savings, thinking their assets were safely tucked away in a high-security vault. In reality, their wealth had been reduced to a series of digital entries in a database that could be manipulated with a few keystrokes. The auditor moved on to the shadow pool entries. These were the most damning pages of the ledger. They detailed the specific dates when physical gold and silver had been sold into the open market to stabilize the bank's fluctuating futures positions. This wasn't hedging, it was cannibalization. They were eating their own tail to keep the beast alive. The ledger proved that this was not a temporary liquidity problem, it was a permanent structural deficit. The bank was, for all intents and purposes, a zombie institution, kept alive only by the lack of transparency in the derivatives market. The courtroom atmosphere was no longer just tense, it was hostile. The judge looked at the bank's legal team and then at the ledger, his expression one of profound disappointment. He recognized the implications. If this became public, it would trigger a run on every bank that utilized similar settlement structures. The paper-to-physical ratio was the industry's dirtiest secret, a fragile thread holding together the global commodities market. By bringing this to light, Martha and her husband's ledger had effectively ripped that thread. Thorne attempted to call a witness, an expert from the banking industry who would testify about the standard nature of these practices. But as the expert took the stand, he faltered. He looked at the ledger, then at the auditor's report, and then back to the gallery. The professional solidarity began to crack. He couldn't lie in the face of such granular evidence. Under cross-examination by the plaintiff's counsel, the expert admitted that while these practices were widespread, they were fundamentally unstable. He conceded that the ledger's math was sound. The bank's defense had evaporated. Martha sat in her chair, feeling a profound sense of closure. Her husband had been mocked, ignored, and eventually pushed out of the industry for asking the right questions. He had been labeled a conspiracy theorist, a man out of touch with the modern efficiency of digital finance. Now, the very system that had cast him aside was being forced to account for his warnings. The ledger was the final word. It was a testament to the fact that you can manipulate the digits on a screen, but you cannot change the physical laws of the universe. If you promise an asset, you must have it. Anything else is just a lie, waiting to be found out by someone who cares enough to count. As the afternoon light began to fade, casting long, sharp shadows across the mahogany floorboards of the courtroom, the judge called for the final witness. The bank's CEO, who had been hiding behind legal counsel for the entire duration of the case, was finally being called to the stand. The ledger had brought them to their knees, but the final act of this drama was about to expose the rot at the very top of the institution. The room held its breath, waiting for the inevitable moment when the mask would finally slip, and the true cost of their modern finance would be laid bare before the court and the public. The CEO of the bank, Arthur Sterling, stepped onto the witness stand with the practiced, stiff-backed posture of a man who had spent his life winning. He had groomed his image for decades, silver-haired, impeccably tailored, and always projecting the calm assurance of a steward of generational wealth. Yet, as he looked toward the defense table, he saw Marcus Thorne staring blankly at the floor. The ledger, sitting open on the judge's desk, seemed to radiate a cold light. Sterling knew that his legacy was not just being questioned, it was being erased in real time. The cross-examination was swift and brutal. Martha's legal team didn't need to employ complex maneuvers, they simply presented the ledger's specific entries alongside the bank's official public statements from the same dates. The contrast was startling. For every quarter the bank claimed record-breaking physical security, the ledger documented a mass exodus of assets into the dark pools of the private equity firms Sterling personally owned. When asked to explain the discrepancy, Sterling tried to use the same jargon Thorne had deployed earlier, referencing liquidity optimization and dynamic reserve adjustment. The judge slammed his gavel, silencing the room. "Mr. Sterling, this is a court of law, not an annual shareholder meeting. We are not interested in the euphemisms you use to disguise your mismanagement. Tell us, in plain language, did you or did you not knowingly sell your client's physical assets to cover your own firm's speculative gambling debts?" Sterling hesitated. The silence stretched, turning from a tactical pause into an admission of guilt. He looked at the ledger, then at the gallery, and finally at Martha. He saw no triumph in her face, only a quiet, resolute sadness. He understood then that this wasn't about the money, the millions they had stolen would be recovered, the bank would be restructured, and his career would be incinerated, it was about the integrity of the contract. He had broken the one promise that held the entire system together, the promise of safekeeping. "We believed," Sterling began, his voice raspy and devoid of its usual resonance, "that we were smarter than the market. We believed that we could manage the risk by leveraging the paper derivatives. We thought that by the time anyone noticed the physical shortfall, we would have already recouped the value through our other ventures." It was a confession of arrogance. He wasn't apologizing for the fraud, he was explaining his belief in his own superiority. The admission of guilt was absolute. He had essentially confirmed everything the widow's husband had spent his final years documenting. The fallout was immediate. Within hours, the regulators had moved to freeze the bank's assets, pending a complete, independent forensic audit of all physical and derivative positions. The stock market reacted with a violent downward spiral, the news of the shadow ledger had leaked, and the confidence that had buoyed the entire commodities sector was shattered. Banks across the globe began to report a surge in requests for physical delivery, a run that threatened to expose the same vulnerabilities the ledger had revealed in Sterling's firm. Martha left the courtroom as the evening news was already broadcasting images of the bank's headquarters, now under the control of government auditors. She didn't stay for the final verdict, she didn't need to. The truth had been established, and the institution that had dismissed her with a smirk had been brought to its knees by a single, physical artifact of reality. She held the photocopy of her husband's last entry, a note he had written the night he died. It was a simple sentence: "The truth is the only asset that cannot be shorted." The legal settlement that followed was historic. The bank was forced to liquidate its remaining interests to satisfy the claims of the thousands of depositors who had been deceived. The paper-to-physical ratio became the subject of a new, global regulatory standard, forcing transparency into the dark corners of the commodities market. It was a total victory for the truth, but for Martha, it was simply the end of a long, exhausting crusade. As she walked out of the courthouse and onto the rain-slicked pavement, she looked up at the towering glass skyscrapers of the financial district. They looked less like temples of progress and more like monuments to a fragile illusion, a collection of mirrors that had finally been broken by the weight of a single, handwritten book. The case of the widow against the banker became a cautionary tale for the industry, a reminder that no amount of digital innovation or institutional power can truly replace the necessity of holding what you own. Sterling served his time, and the bank was rebranded, but the story remained, a testament to the fact that when the ledger is balanced, the truth is always the only thing that remains. Martha returned home, placed her husband's tools back on his desk, and for the first time in years, she felt the quiet, steady weight of peace. The smirk had been silenced by the ledger, and the missing truth had finally been brought home.